friend will withdraw the amendment following the reassurances I have provided.
My Lords, I'm grateful to noble Lords who have taken part in this short debate. If I could start briefly with the noble Lord Kennedy of Southwark, keen to fly. He said at the end about Heathrow expansion, we should get on with it. Now, I'm not myself necessarily a believer that textual exegesis is the right way to approach a winding up speech even in your Lordship's house. But it's this question, what is we in that sentence, that is at the heart of this? Because if it was purely a private planning application, it would mean the developer. But of course, I don't think that that's what the noble Lord meant when he talked about Heathrow. He meant either we as a government or we as a nation, we somehow bigger than just the private sector developer should be getting on with it. And it's that blend that is involved in nationally significant infrastructure projects, where, as I say, the government sort of makes itself a co-partner with, in the case of Heathrow and the other example I gave, both private sector developers. It's that confusion about who is responsible that I'm trying to get to here, because we know the government is responsible to some extent with a project like Heathrow expansion. We know they are, but what are their responsibilities in relation to the consequences of it, and are they actively monitoring? That is really my question. The noble Baroness, Lady Hayman of Ulloch, I'm sure understood that I was not, in anything I said, criticising the process as such, or saying that there wasn't the need for a process that would speed large applications through the system, although it is undoubtedly the case that the speed with which that process, the DCO process, is handling applications is getting slower and slower, and everybody involved with it knows that. And it may well be that a time for a refresh is coming. I don't think it's simply skills. It's also demands for additional upfront information and so forth. And this is something that the committee, the Built Environment Committee, which I chair, may well come and look at again. It was the noble Lord Stunnell who put my purpose most. I don't know why he said he was only 3/4 supporting my amendment, because I thought he gave a 100% endorsement. I don't know what reluctance it was that prevented him from coming out wholeheartedly, because he also put my purpose very, very well, which was, although I invited my noble friend to accept the amendment, he recognised, and I'm sure she does, that it's essentially a probing amendment to try and find out what it is the government does, how it takes its responsibilities for these projects forward. And I have to say, I found her response, and I welcome her response, but it was slightly on the disappointing side. Of course, it is wonderful that I did not know that an interministerial group is being set up to look at these issues, but she slightly took the benefit of that away, I thought, when she said it shouldn't look at individual projects, where it's precisely individual projects that I would like ministers to look at. Now, I appreciate that a planning minister who may have to take planning decisions may... Of course, I'm sorry if I've misunderstood.
We will look at cross-cutting issues on projects, but it cannot get involved with the specifics of a project in order not to prejudice decision-making. It's the specifics. I didn't say it couldn't look at individual projects.
Well, I'm grateful for that. But, of course, thanks to a judgment in the courts a year or two ago relating, I think, to the Holocaust Memorial, and I can't remember the name of the judgment, unfortunately, local planning authorities have been required to put in place in the last year or two rigorous separations between, and Chinese walls as they're called, between those officers who actually work on developing the council's own applications and those who are assessing them in a way that always existed to some extent but is now very much more rigorous. And if it is the case that ministers, including the planning minister, are understandably inhibited from getting into the details of why a project isn't happening, perhaps a similar arrangement could be achieved in government, so that maybe somebody in the Cabinet Office or whatever took on the responsibility for getting into the weeds of projects that weren't happening, and either helping to make sure they did or cancelling them. But I'm grateful to my noble friend for acknowledging that ministers do have the power to remove an NSIP designation. I'd like to think that they could remove it on grounds more expansive than those she mentioned. The grounds she mentioned that it was no longer an appropriate designation. I'd like to think they could remove it on the grounds that it simply wasn't happening, and therefore was an irrelevant designation in practice. But she didn't say that, but perhaps it was encompassed in what she said implicitly. And I would like to think that any ministerial involvement that is now getting going, which I wholly welcome, could be structured in such a way that there were ministers who are able to get involved in the weeds. But I'm very grateful for this debate. I think it's flushed out some issues that we wouldn't otherwise have debated. And I'm grateful to my noble friend. And of course, I would, with the leave of the House, beg leave to withdraw my amendment.
Is it your Lordship's pleasure that this amendment be withdrawn? Amendment